Good morning, everyone. Thank you for participating with the Governor's Committee on People with Disabilities. Today, we have an Office of Injured Employees Counsel here to present about accessing workers' comp benefits. And before we get started and turn it over, we want to talk about a few basic guidelines. First of all, if you want to change your captioning settings, you can ask that in your Q&A to ask for those that link that you can accommodate yourself. And also, if you need a sign language interpreter, you can click on the interpreter button to access the sign language interpreters. The chat is not available today in our webinar. That means that if you have any questions, you can use a Q&A button. That way you can request for questions for the presenters. And we will answer those questions at the end of the conference. Now, after presentations, you receive an option to complete a survey for feedback. That way we'll also send you an email later on if you'd like to give us some feedback in the future. The email will also include a link to our page if you want to copy a copy of the recording or to see the PowerPoint or any other materials. Now, let's go ahead and turn it over to our guests. And this will be Caitlin and Alex.
Hello, everyone. I wanted to start by saying thank you for joining us today. My name is Caitlin Kelly. I'm the communications coordinator with OIEC, and with me is Alex. I'll let him introduce himself if he wants.
Good morning, everyone. My name is Alexander Elias. I am the regional manager for the Region 5 at the Office of Injured Employee Counsel, and I have the office in Austin as well as in Houston West. And thank you for the invite.
He is the brains of our operation here today. So he will be here to answer any of your questions and give some of his hands-on experience with workers' compensation. We can go to the next slide. So I'll start with giving kind of an overview of what is workers' compensation. So workers' compensation is a state-regulated insurance program. It helps cover medical bills and pays a portion of lost wages if someone was injured on the job, as long as their employer has workers' compensation coverage under the Texas Workers' Compensation Act. So in Texas, workers' comp is actually not required for most employers. The main exceptions are certain government entities, educational institutions, and some private employers. Sometimes if they have a contract, a construction contract with a government agency, or if they're in the same building as a government agency, they have to adopt a workers' comp policy. One of the key concepts in workers' comp is what's called the grand bargain. So basically this means employees can receive medical treatment and income benefits if they're hurt at work, but in exchange, they generally give up the right to sue their employer, except in very limited situations. There are several groups involved in the workers' compensation system. This includes injured employees, employers, insurance adjusters, healthcare providers, attorneys, and OIC ombudsman, and our other staff like customer service specialists and things like that. We can go to the next slide. Okay, and then I'll give you an overview of what is OIC. The Office of Injured Employee Counsel, or OIC, was created in 2005 by the Texas legislature. Its purpose is to help injured employees or their beneficiaries who don't have an attorney so that they can better navigate the workers' compensate dispute process. So OIC is a state agency. It's led by Public Counsel Robert Rucker. It is also administratively attached to the Texas Department of Insurance, and I'll get into that more a little bit later. We can go to the next slide. So our field offices, we have 20 field offices in the state of Texas, plus a central office located in Austin. All of our offices are also co-located with the Texas Department of Insurance Division of Workers' Compensation. Statewide, we have over 160 employees, and most importantly, our dispute resolution services are completely free and available to injured employees in any city in Texas. Next slide. So a little bit more about the Division of Workers' Compensation and Office of Injured Employee Counsel's role in workers' compensation. The Texas Department of Insurance Division Workers' Compensation, also known as DWC or DWIC, regulates the workers' compensation system. OIC, on the other hand, we serve to assist, educate, and advocate for injured employees. So DWIC is responsible for monitoring compliance across the system, and that usually includes injured employees, employers, healthcare providers, insurance carriers, and attorneys. When necessary, DWIC will also take enforcement action to make sure that the Texas Workers' Compensation Act, the Texas Labor Code, and other regulations are being followed. Next slide, please. So, disputes versus complaints. It's important to understand the difference between the two because that determines how the issue gets solved. A dispute is a disagreement between two parties. So, for example, an insurance carrier might accept a back strain as a part of an injury, but denies a related neck injury. So, that would be the dispute. A complaint is an allegation that someone in the system violated the law. So, for example, if an insurance carrier issues a payment late, that would be considered a complaint. So, complaints are handled by DWIC since they regulate the system, and disputes are handled by OIC. OIC can also help with complaints. We can help file complaints, but we do not regulate or handle them. So that's a big distinction that we try to make. And overall, disputes typically involve disagreements about a workers' compensation claim, either medical issues or income benefits, and we'll go into that more a little bit later too. Next slide. So OIC's mission is carried out by different program areas. Our mission, again, is to educate, assist, and advocate on behalf of the injured employees of Texas. So our customer service program, they educate customers by answering questions, making referrals to other agencies, and resolving informal disputes that can be resolved fairly easily. Our ombudsman program, they assist injured employees who do not have an attorney through the workers' comp dispute resolution process, and our legal services advocates on behalf of injured employees as a class. They do this by identifying issues in the workers' comp system as a whole and addressing them through legislative and rulemaking processes. Next slide. So what happens when there is a dispute? Even in the best situations, disputes can come up in a workers' compensation claim that aren't easy to resolve. An income benefit dispute involves disagreements about compensability or eligibility for income or death benefits. In simple terms, this often comes down to whether the injury is work-related, meaning it arose out of in the course and scope of employment, and whether the benefits should be paid. And then a medical dispute typically involves issues like pre-authorization, medical necessity, or medical fees. OIC helps with both of these types of disputes. And for now, we'll go into a little bit more of the income benefit disputes. Next slide, please. So income benefit dispute resolution. If an injured employee has a question or dispute, OIC customer service specialists are often the first point of contact. In some cases, they can resolve the issue quickly with a phone call or some brief research. If the issue can't be resolved at that level, then it is referred to the ombudsman program for more in-depth assistance. The ombudsman will meet with the injured employee, gather relevant information, help develop the claim, and work to resolve the dispute. In many cases, this is successful, but however, if the dispute still can't be resolved, it may move in to the DWC dispute resolution process, and this can include one or more of the following steps. So a benefit review conference, then a contested case hearing, and then a review by the appeals panel. And the ombudsman can assist the injured employee through each step of this process. Next slide. So medical disputes. Medical dispute resolution is a process used to address different types of medical disagreements in a workers' compensation claim. So these disputes mainly involve three areas. It's pre-authorization disputes, retrospective medical necessity disputes, and medical fee disputes. At its core, this process determines whether medical treatment is reasonable and necessary. So reasonable medical care means treatment that meets the standard of care generally accepted by the medical community, and necessary medical care means treatment needed to cure or relieve the effects of a work-related injury. So in order for the injurer or for the insurance carrier to be responsible for the payment, the care must be both reasonable and necessary. These types of disputes often involve questions about the severity of the injury or whether certain treatment should be covered. OIEC can assist disputes involving additional compensable injuries or denied injuries. So, for example, if someone slips and falls at work and is diagnosed with a knee sprain and a tore ACL, the insurance carrier might accept the sprain, but then they dispute the ACL tear. In that situation, a dispute is created, and the burden of proof is on the injured employee. Next slide. So, in the dispute process, if you do have a dispute, this would be the beginning. A benefit review conference or BRC is a non-binding mediation. It's an informal proceeding and it is typically held online. A DWC benefit review officer conducts the conference, and this person is impartial and trained to help both sides work towards the resolving of the dispute. The ombudsman can assist the injured employee before and during the BRC. So before the conference, they'll meet with the injured employee to help them prepare. And this comes with reviewing the case, gathering information, collecting any necessary documentation to support the dispute. The ombudsman also requests copies of medical records on behalf of the injured employee, and those records should be provided at no cost. During the BRC itself, the ombudsman will attend and assist the injured employee by helping present their position and participating in the informal discussion. If the parties reach an agreement, it is documented as a dispute resolution agreement, and it becomes legally binding once it is approved by DWC. So, the possible outcomes of a BRC include the dispute is often resolved on the same day as a conference. Sometimes another BRC is scheduled so additional information can be gathered. And in other cases, the dispute is not resolved and it moves on to a contested case hearing, which the next slide is about. Next slide, please. So once an injured employee has gone through the benefit review conference and the dispute is still not resolved, the case moves on to a contested case hearing or a CCH. This is a formal hearing or a trial where evidence is presented and testimony is taken. It typically lasts about 2 hours and the decision is binding unless it is appealed. The hearing can be held virtually if all parties agree. That's actually new, so that is important to mention. If the injured employee chooses to have ombudsman assistance, the ombudsman will meet with them again to prepare for the hearing and plan what is needed to present the strongest case possible. So a key part of preparation, exchanging all documentary evidence that may be used at the CCH, and the ombudsman may also recommend using discovery tools such as subpoenas to obtain additional information. And then at the hearing, the ombudsman will attend and assist by presenting opening and closing statements, as well as questioning or cross-examining witnesses. The hearing is presided over by the Division of Workers' Compensation Administrative Law Judge, who makes a decision based on the evidence and testimony presented. Because of this, it's very important that the injured employee is fully prepared. So then after the hearing, the judge issues a written decision on the disputed issue. In most cases, either party has 10 days to appeal if they disagree. If an appeal is filed, the appeals panel will review the case and decide whether to uphold the decision, reverse it, or send it back to the judge for further review. In most cases, the injured employee should also expect to be cross-examined by the carrier's attorney during the hearing, and we can also assist through the appeals process if needed, which we can get to in the next slide. Next slide, please. So then the appeals panel, if any party disagrees with the decision made by the contested case hearing administrative law judge, they can file a appeal. After the hearing, the ombudsman can provide information to the injured employee about requesting a review by the appeals panel, and the ombudsman can also help with filing and responding to an appeal. But this is the final step where OIEC is involved. We're not authorized to assist with legal representation to that extent. So the appeals panel is made up of 3 judges who review the administrative law judge's decision. Their role is to determine whether the law was applied correctly. So the panel may affirm the decision, reverse it, or remand it for further review, or kind of issue a combination of any of those. It's also important to note that the appeals panel can only review the evidence that was already presented during the contested case hearing. So if you file a appeal, you can't come back with more evidence. It's just the evidence that you had in your CCH. If a party still disagrees after the appeals panel, they may file a lawsuit in district court. And like I mentioned earlier, OIEC is not authorized to assist with state court lawsuits, so legal representation is typically needed at that stage. Next slide, please. So disability and in the workers' compensation system. The most important thing to understand is that disability in the workers' comp system is a little bit different from how it's used in Social Security or other laws. So in workers' comp, disability is considered an economic concept. That means it's about wages and earning ability and not about physical impairment or medical condition. So disability is defined as the inability because of a compensable injury to obtain and retain employment at wages equivalent to the pre-injury wage. In simpler terms, it means that the injured employee is earning less than they did before the injury because of the work-related injury. There are different types of evidence that can show disability. So, for example, if someone is unable to work at all or can only return with light duty restrictions, that may support a finding of disability. It's also important to know that disability can change or end. So, for instance, if an injured employee is no longer working or is earning less for a reason unrelated to the injury, such as being terminated, then disability may no longer exist. It can also end if the worker returns to earning the same wages as they did before the injury. Disability is important because it is required to receive temporary income benefits, and we'll go more into detail about that next, or I think later. So with this, now let's talk about a couple of topics that relate to a person's physical condition, maximal medical improvement, or MMI, and impairment rating. So these are both medical concepts that deal with how much an injured employee has recovered from their injury. And there are 2 types of MMI. It's clinical MMI and statutory MMI. Clinical MMI is the point where no further meaningful recovery or improvement is expected. So in other words, it's when you've reached like as good as you're going to get medically. A simple way to think about it is like a vase that falls and breaks. You can glue it back together, but the cracks and the damage are still there. It's repaired and it won't fully return to how it was before. So a doctor reviews the medical records and determines the clinical MMI date based on the individual's case. Unlike clinical MMI, statutory MMI is set by law. So that occurs after 104 weeks, so about 2 years from the date of the income benefits beginning. This means that there is a legal limit on how long someone can remain in the recovery period before reaching MMI. In both cases, MMI must be certified by a doctor who is approved by the state of Texas. Once a doctor determines MMI has been reached, they can assign an impairment rating, or IR. So this is the percentage of permanent impairment to the whole body resulting from the work-related injury So, for example, a doctor might assign an impairment rating that reflects the lasting effects of the injury. So I thought I had a better example. It's okay. Only doctors certified by the state can assign impairment ratings, and they also use the American Medical Association's guide to the evaluation of permanent impairment as the standard reference for doing so. Next slide. Okay, and now this is our income benefit overview. The In the workers' compensation, there are 4 different types of income benefits available to injured employees. We'll briefly go through each of them, but I have these 3 on this slide because these 3 will terminate after 401 weeks after the date of injury. So the temporary income benefits, or TIBs, may be available when an injured employee has a disability. So these benefits are based on the injured employee's average weekly wage, and they are meant to help replace lost income when the employee is off of work or earning less. And they will continue until the employee reaches the maximum medical improvement, or MMI, like mentioned earlier, whether it's the clinical or statutory, or until the disability ends. And then impairment income benefits, or IBs, begins the day after the temporary income benefits end. So these are based on the impairment rating assigned by a certified doctor after the evaluation. And at this stage, we are no longer looking at disability or the maximum medical improvement. It's based solely on the impairment rating. The calculation is simple. The injured employee receives 3 weeks of benefits for every percentage point of the impairment. So, for example, an impairment rating of 10% would equal 30 weeks of IBs. And then supplemental income benefits, or SIBs, may begin after the IBs end. So, at the end of, as the name suggests, these benefits help supplement income while the injured employee continues to recover and attempt to return to work. And to qualify, there are several requirements, but one of the most important is work search activity, meaning the injured employee must look for work, working in some capacity, or has a doctor certification that they cannot work. SIBs can continue for an extended period of time as long as the eligibility is met. Next slide, please. This is still the income benefits. So these are the last 2. These are not, these do not end. So lifetime income benefits, or LIBs, they do not have a time limit and are paid for the lifetime of the injured employee. So to qualify, the injured employee must meet specific severe criteria such as amputations, paralysis, traumatic brain injury, things like that. Finally, there are also death benefits. These are paid to the legal beneficiaries of the deceased employee when a compensable work-related injury results in death. Next slide, please. Okay, so our ADA accommodations. We assist many injured employees who are dealing with temporary or permanent disabilities, and one of our ongoing priorities is making sure that all of our injured employees can access our services and fully participate in the dispute process. So one important improvement that I mentioned earlier from the most recent Texas legislature is that the CCHs can now be held remotely. This can be especially helpful for individuals with limited mobility, or those who are able to participate more easily from home using their own resources. One thing to note is that remote hearings typically must be agreed by both parties. However, the Division of Workers' Compensation also has the discretion to set a hearing as remote. Currently, about 11 to 12% of injured employees choose to participate in hearings remotely. And anyone who needs an accommodation, auxiliary aid, or service for effective communication, or a modification to policies or procedures in order to participate in a program, service, or activity can contact our ADA coordinator, Kathleen Contreras. Her email is kathleen.contreras@oiec.texas.gov. We ask that uh, we ask for at least 48 hours before the scheduled event. Sometimes providing certain accommodations may require coordination with outside resources. So we ask for as much notice as you're able to give, but at least 48 hours. Next slide. Okay. And then so we have an early assistance program. Our assistance program consists of a manager, assistant manager, ombudsman, and customer service specialists. So when a claim comes in, it is first routed to the early assistance program. At this stage, our customer service specialists, they provide immediate contact with the injured employee and they'll follow up as needed. And then the ombudsman, they'll work to help resolve issues or disputes early whenever possible. They prepare cases before they are sent to higher level ombudsmen if further assistance is needed. Throughout this process, we help educate injured employees about their rights and what options are available if disputes arise. Overall, the early assistance program helps us get involved sooner, which can reduce delays and shorten the overall dispute resolution process. Next slide. We also have a first responder unit. So I don't know if any of you guys are first responders, but in 2023, OIC launched a special unit to assist first responders who are involved in workers' comp dispute resolution process. So instead of initially being handled through the early assistance program or one of our field offices, first responder cases are routed to and processed by the first responder unit. This unit includes a manager, assistant manager, first responder liaisons, and these are designated ombudsmen who specialize in helping first responders with their disputes and first responder liaison assistance. So this dedicated staffing is put into place to develop first responder cases earlier in the process, maintain regular contact with injured first responders to provide updates and address questions or concerns, and provide training to ombudsmen and staff across OIC's 20 field offices. So a little bit more information about that. Sometimes cases for first responders just require a little bit more documentation and things like that. Some of the things qualification wise are different. So that's why we have a separate like task force for them. Next slide. So some general tips for injured employees that apply to pretty much every workers' comp claim is that injured employees are responsible for their claim and should remain in contact with their employer, doctor, insurance adjuster, their OIC ombudsman, or attorney if they have one. And it's also important to keep all paperwork. Paperwork is so important. In workers' comp, there's so much paperwork involved. It's really important to stay on top of that. You also have an obligation to report your injury within 30 days to your employer and 1 year to DWC. I wanted to mention that because it's really important to be prepared, to be timely, and to really get assistance when you need it. Waiting is never a good option. We do not advise you to wait. And having the following information would make it a little bit easier. To get assistance from OIC, you have to fill out an intake packet, and it usually asks these things. So job title, job function, medical history of injury, expert opinion from a doctor. Next slide. I'll go over these quickly, but these are our success stories. So OIC has had a ton of success over the years. We actually just hit our 20th anniversary. So these two, Homer Salinas and Carrie Stewart, they're both firefighters, actually, first responders, and I'll kind of explain as I talk about them. Maybe provide a little bit more information about why first responders are a little bit harder. So I'll go into each of their stories. Next slide, please. We'll start with Homer. So Homer has been a firefighter in Mission, Texas since 1993, and in 2017 he was diagnosed with renal cell carcinoma. So that's the most common type of adult kidney cancer. And something that's important to note is that he was a non-tobacco user and his spouse was a non-tobacco user, non-smoker. So that's one of those things where, since he was a firefighter, they could easily say, oh, well, how is that related? Or, you can't prove that this cancer was because of this job. So he had multiple surgeries to remove the mass and determine his treatment, but he did end up having to receive chemo treatments. And because of that, he was not able to work for a period of time. And I don't know if it mentions it in the video, but the next slide is a video of him returning to work. So that's always nice to see. But he did end up going back to work. Next slide, please. And I also think if it's needed, you can turn on the captions, but the auto captions might be fine. You can play it. Okay.
I'm going to go ahead and adjust the audio.
Okay.
Okay, now audio should be on
Okay.
now.
Lieutenant Homer Salinas, his battle with cancer and his fight for workers' compensation.
Channel 5's Carolina Cruz followed the story from the beginning. She was there this morning as the man who lives to protect you returned to work.
It's anything but a typical Wednesday morning.
It feels so good to come back to work.
Back in the truck? Have a good ride.
Just a few months ago, this moment was hard to picture.
When I left, I thought I was never going to come back.
Lieutenant Homer Salinas was diagnosed with kidney cancer in October of last year. He battled it for months and won. This is his first day back.
Make it official, right?
7 months waiting for this moment.
There it is. I'm on the clock.
Like reuniting with old friends, time passes, but their bond didn't skip a beat.
Make the donuts.
I was like a little kid on the first day of school, jeering to come back to work, and it's just been awesome. And coming back to work, I know things get back to normal.
His routine the past few months was hospitals and medical treatments. This is his true normal.
So happy to be out there and helping people. That's what I live for. They asked me how long I've been a firefighter. I think since the day I was born. That's what I wanted to do.
Salinas argues his kidney cancer was caused by his over 20-year career. Some studies back it up. The fire department made changes to prevent future cases. Those new life-saving measures come in the form of a bucket.
Inside is the brush, some trash bags, gloves, soap, and this is what they use. What's contained in here is what's used to do the decontamination on the scene.
Firefighters also get wipes to clean off any debris on their neck. The area is known to easily absorb carcinogen particles.
So by taking off the particles, it prevents them from bringing it into the truck and then bringing it, hopefully, not bringing it to the station.
If we can prevent any little thing, that is great. And I'm glad that we're implementing this yes, not only for other firefighters, but yes, my son.
That's right, his son is a firefighter. It's become a family tradition.
And my youngest son wants to. He's still in high school, and that's the first thing he wants to do when he gets out of high school.
Salinas hopes these simple changes keep him, his crew, and his children safe from the deadly disease he's overcome.
Salinas is still fighting his workers' compensation claim with the City of Mission's insurer, the Texas Municipal League. Also, he's cancer-free now, but his battle with cancer continues since he has to visit Houston on a regular basis for checkups. Reporting in Subcontrol, Carolina Cruz, Channel 5 News at 6.
Okay, we'll move on to Carrie Stewart's. His was a little bit more not positive. I mean, he still has to fight his dispute and everything, but Carrie kind of went through a tough process. So in 2015, she was diagnosed with breast cancer. So they both had to deal with cancer. And doctors determined that her cancer was work related because she was also a firefighter. They pointed to her working 24-hour shifts, and the city was ordered to offer her workers' compensation in 2016. The the Texas Department of Insurance Division of Workers' Compensation, they ruled in her favor and determined that her cancer was actually work related. But then the city filed a petition for judicial review to declare that her particular injury is not work related and that she is not entitled to benefits. But they actually dropped the lawsuit a few years later. So that was a good outcome for her too. Next slide, and that will be also her video. You can start that.
Worker. My favorite part of the job is riding around on the big red truck, and there's so many things that can be a part of that, whether it's interacting with the community or waving at little kids who are in the car next to you, or going to the grocery store and just interacting with the public. But there's also the parts of when people call you on the big red truck, they're having a really bad day usually, whether it's a medical emergency or a fire or some sort of other car wreck or other emergency. So being able to respond on that big red truck and make that day better or solve that problem for someone. There's so much that goes along with being a firefighter and riding around in the truck, and that's my favorite part about it, is just being able to be on that truck and kind of affect change that way. Firefighters do have higher rates of cancer just because of some of the carcinogens that we're exposed to in smoke and products of combustion and burning. And there are also higher rates of other cancers from shift work itself is considered a carcinogen. So I was diagnosed with an occupational cancer in May of 2015. The ombudsmen that I've been able to work with have been amazing. And we're working under presumptive law for firefighters for cancer and some other occupational illnesses. And some of the education for that presumptive law and for firefighter occupational illnesses isn't really common knowledge sometimes, and so it's kind of been a learning process for both members of the fire department and the fire service, and working with the Office of Injured Employee Counsel. But it's such a collaboration to work together and to gain that knowledge and experience and education together. And so we kind of have taught each other about the processes or about firefighting or the presumptive law. But I've been so amazed at how much people here have been willing to jump in and learn about our job and learn about the presumptive law so that they can continue to help not only me but other firefighters that are facing the same illnesses or the same issues. Nancy is a rock star. She's amazing. And so she's willing to jump in with other cancers, and she's learned so much, and we've been able to teach each other so much that like she's who we want to go to now.
These cases do take a lot of work and a lot of research just to ensure that we are covering everything. But the end result is a great feeling when these injured employees can prevail, especially these first responders.
After filing a claim and I learning about the process that I could stay with an ombudsman until I felt like I needed any legal representation if I did. So I went down the ombudsman route just because that was kind of where the process directed me, and just filing paperwork and knowing that this is where benefit review conferences happen or contested case hearings, and just being, it was kind of necessary to become familiar with the office.
Okay, so that is both of our success stories. Well, I mean, we have more, but those are the ones I included. Sometimes it's kind of just good to hear from people that have been helped before from their own mouths. And something that she mentioned that I wanted to kind of point out is that again, is that all of our services are free. And people do a lot of research, and like OIC is here for injured employees. It's our job to, look into these cases, help you guys. And I've talked to so many ombudsmen where, not that they are doctors or anything, but they sound like it to me. They talk and they say stuff where I'm like, okay, did your research. You looked into this medical procedure, you looked into this medical diagnosis, and you know what you're talking about. So it does require a lot of research, a lot of effort from our ombudsman, a lot of collaboration too with the injured employees. So I feel like something that is kind of misconstrued a lot. I know that people, workers' comp is complicated. Claims aren't always guaranteed to work out how everyone hopes they do. So we're not here to fight you. We're not here to, mess up your case or anything like that. We're here to help, assist, educate, advocate. We're here for you. So to wrap up, I'll talk about some kind of return to work resources. So once the whole process has kind of, come to an end, something that will probably happen is a bona fide offer of employment. This is a written offer of employment. It's a letter from the employer offering modified or alternative work to an employee within their medical restrictions due to the work-related injury. So this offer must be provided to the employee in writing, and it must include several key details. So first, the job must be consistent with the doctor's certification of the employee's work abilities. Second, it must include the location of employment. And it has to take into account these factors, the employee's physical limitations and how that affects travel, the distance the employee must travel, the availability of transportation, and whether the work schedule is similar to what the employee had before the injury. Third, the offer must include the work schedule. Fourth, it must state the wages being offered. And fifth, it must include a description of the physical and time requirements of the position. And finally, it must include a statement that the employer will only assign tasks consistent with the employee's physical abilities, their knowledge and skills, and provide training if needed. Next slide. So this next slide is some return to work resources. The Division of Workers' Compensation, they provide a lot of information and education about return to work programs for both injured employees and for employers. And I for healthcare providers, I believe so too. And they kind of give an overview of what injured employees may need in order to return to work safely. So these resources include things like a return to work checklist. They have a video guide. They have employment support resources, and they have a lot of other stuff on there. You can scan this QR code. That'll take you to the webpage. The return to work webpage on their website is also www.tdi.texas.gov/wc/rtw/index.html. They also have a return to work email address that you may be able to contact. It's rtw.services@tdi.texas.gov. If you have any questions or want to know more about getting back to work, you can email them. Next slide. Okay, I believe this is the last slide. So when do you know to refer to OIC? So if you have a Texas workers' comp claim, if you're not represented by an attorney, and you have a possible dispute, you can contact us for questions. If you don't know if your if you don't know if your employer has workers' comp coverage, we can check that for you too. We're always here to help injured employees. Like I mentioned earlier, we want you to better understand your rights. We want the dispute process to go well, and we want to give you all of the options available when things arise in a claim. So for more information from us, you can go to our website. It's oic.texas.gov. You can call us at 866-393-6432. We also we have a lot of videos that might be helpful. There's ones that are for the BRCs, CCHs that kind of give you an overview of how those go on our YouTube channel. It's OICTube on YouTube. I think all of our other social medias are OIC Texas. We usually provide tips, frequently asked questions, things like that on there as well. We also have a main email, so that would be oicinbox@oic.texas.gov if you would prefer to email or have any questions that are easier to email. But besides that, yeah, we encourage all of you to reach out early, please, early, if you have any questions. Getting help sooner really makes the process easier to understand, and it really may help prevent delays in your dispute because there are a lot of deadlines that need to be met. So I want to thank you guys for joining. I think we'll go into questions now. There might be a lot. Alex, if you want to take
Yes.
over.
Yes, I'll open it up to the audience for any questions, and you can use your
Okay.
Q&A button to ask those questions.
Okay.
So I also have a couple questions myself, if we don't have any questions from the audience. The first
Okay.
question would be in regards to how important it is for your word choice that's in the application process, because I see a lot of claims denied because of the wrong word choices when they're filling out that complaint or claim.
I'll answer that. You're absolutely correct. The word choices and whenever you do report your injury can be very, very important in your claim, specifically how you were injured. Also, when did you realize you were injured? We have a lot of injured employees who come in who just feel pain, and the key word is pain in itself is not an injury, but they feel it and they're not aware of an actual injury until they go to the doctor to check themselves out. So you want to make sure that when you do go to a doctor to get checked out for pain, if it's happening because of work, you express exactly what it is. Specifically, for example, I spent all day sweeping a large industrial broom for 8 hours a day, 7 days or 5 days a week. It's very important that you notated that very well because any discrepancies in any other paper, and you're not lying, you're just maintaining how you were injured, that you maintain that information in all the paperwork you file, because sometimes when the carrier reviews your claim on workers' comp, once they find discrepancies, that gives them kind of like the green light to say we're not going to prove it because we cannot determine if this injury was suffered within the course of scope of employment. So documentation and also how you were injured, what you call the mechanism of the injury, just a fancy word for saying how you got hurt, is very important to be consistent and documented in your report to your employer and to the insurance carrier that covers the employer.
Okay, and also I asked that same question because a lot of people out there with disabilities have a language barrier, so maybe they don't have that awareness of correct word choice to fill out to file that claim, and then it would become a dispute within your organization to get assistance because sometimes what they fill out is not exactly what they necessarily meant, so they need more expansion, more clarification on that.
Yes, and so what we do have here, do have an ADA coordinator. If you ever have a situation where, remember, you have 30 days to report your injury to the employer. If you ever have any questions of how you can report it, you can contact us. We do have an ADA coordinator that could give us ASL interpreter for us if needed. We also have individuals who may use I forgot if that technology is still around or not, but they do it over the phone. But we have
The relay
resources available
service,
to us.
the relay service.
The relay service. But we do have resources available to us to help, even when it's just reporting the injury to the employer. That's what we're here for, to give you the resources to make sure that you document it correctly to avoid any disputes down the line.
Okay, and then secondly, my next question, this regards to If a person has a disability that's existed before the injury, um, who would be responsible to help them, with those accommodations to filing of their claim? Initially, with their employer, would it be the filing with the employer or the insurance company or the employee?
The employee, even if they have pre-existing injuries or another condition that exists, that doesn't automatically disqualify them. So if you have a previous injury and we call it aggravation, or a situation where you had a disability that's aggravated because you were furthering the business of your employer, you still report it to your employer. You just say, yeah, I've had it before, but it just got progressively worse or it got aggravated within the course of scope. So you do want to report it to your employer. And then the insurance carrier may have additional questions that you report to them. And if there's ever a dispute, you contact the Office of Inter-Employee Counsel. We could help you. We could assist you to pursue your dispute or pursue your claim as an aggravation.
Okay, awesome. And thank you. That's good to know as well. But still, that didn't answer the question. Who would be
Oh, I'm
responsible
sorry.
for those accommodations? For example, I believe that most of the time, the workers' comp claim, you would have to go to that doctor they refer you to. So what if that doctor doesn't know about the accommodations and getting sign language interpreters or Braille, providing Braille or other types of accommodations? Who would be responsible for that?
The injured employee is the best advocate for themselves to try to get them, but their employer, human resources department, should be able to help them with those accommodations if needed. It usually relies on the employer. The the insurance carrier does get involved, but that's when it's an accepted claim or they're denying the claim. But the employer should be the main source of contact to try to make those accommodations for the injured employee.
Okay, perfect. Thank you. Thank you. I'm looking to see if we have any other questions. Okay, so we might have one more question in regards to Social Security disability benefits. Can they still apply for Social Security benefits if they're going through a a workers' comp claim, or do they have to use up their workers' claim benefits first?
So you're talking about Social Security benefits, like the monthly payments. Just
Yes,
because you're
for disability benefits, yes.
okay, yes. You still want to go ahead and follow the process to report your injury to your employer. I do know that some insurance carriers do their research on when it comes to lost income. If you are earning Social Security benefits while also employed, it doesn't automatically mean you're not entitled to any additional benefits. So it's on a case by case basis. It's still you don't want not to report something because you're on Social Security. We have many people who are retired and go back to work and they get injured and they do receive Social Security benefits, but they are still, they may not be earning the income that they were because of the injury. It is a possible denial by the carrier, but doesn't mean that the carrier is right all the time. So just because you're earning it doesn't mean that you don't have the right to pursue it.
Okay. Okay. So whenever an individual applies for their Social Security benefits, if they don't have anything previous to that, will workers' comp claim impact their ability to get the benefits from Social Security?
Repeat your question one more time.
So with Social Security disability benefits, they have
Mhm.
limitations on your income. Now, some people
Mhm.
who have not filed for their claim for disability, but they were injured enough where they're going to be able to get their disability benefits now, and they want to file, file a claim for disability benefits, but also do the workers' comp at the same time. Can you
Mhm.
do both?
You could make the attempt. I don't want to discourage anyone from not filing because of Social Security, because if we're injured on the job, you have they're covered. They're liable. They're possibly liable for all the missed income as well as the treatment. And so it could get to the point where they may be able to get treatment, but they may not be able to get their benefits. But that's on a case by case basis. So it's a situation where I cannot give you an overall answer because it's not an absolute answer. But you do want to make sure that if you ever get injured, you still pursue it and you still pursue the benefits. But if you're on Social Security, we could give you resources to refer you out to Social Security who may be able to answer that question directly. But in our situation, we're going to go ahead and assist you with the workers' comp benefits or any missed income that you're entitled to. And if you are earning Social Security or about to go Social Security, we could refer you out to the proper individuals to give you the correct overall answer for it based on your situation.
Okay. Okay. I think that, we do have one more question.
Okay, so it's kind of worded just with a few words. So I'm assuming it was coming from follow-up of a previous question. So it said, what if it's years past due or if it's an intellectual disability?
We do have situations where we have injured employees who were hurt years prior, but they reported the injury, and they just didn't follow up with it, but it was reported. There are some claims that are time sensitive that have to be handled within a specific time frame. But we do have other injuries that are not bound by any type of deadlines. For example, the extent of the injury. You had an injury at work, but then you were diagnosed with a rotator cuff. At the time, there was no doctor willing to provide you a letter to assist you to, get your burden approved. But then years passed by, and then you found a doctor who's the best doctor in the world. He's willing to fight for you to get you to prove that specific extension of your injury was caused by the original injury. And you can pursue it now. They give you the evidence, you can pursue it. There's no time frame. So if there's a situation where you were not able to report it because of a disability, you can still try to pursue later, and you may fall under the exceptions of the law that gives you the opportunity to pursue it down the line. Even though we have some claims that are time sensitive, they have to be filed. There are some exceptions to the law on a case by case basis. I'll give you an example of one that is a little bit different, but there was a death claim that's bound by a specific time frame that they had to report it. But we were able to find a loophole, and this was years later, that the employer never reported it to the actual insurance carrier when it happened, and once the employer for whatever reason decided to report it, the insurance carrier automatically denied it because they said it was past the deadline. But we were able to find out, well, past what deadline, because you weren't aware of it until in September, and they pursued it in October. And so I'm glad to say that that loophole was actually a very legitimate loophole, that the claimant was able to get, the beneficiary was able to get death benefits years after the initial unfortunate death of the actual injured employee. But so there is possibilities that even if you're delayed in pursuing it, you can still pursue it.
Well, so one more question for you then, before you wrap it up. So I have noticed that you're doing a lot of support for employees who are injured or have disabilities. But what about the employers? If the employer has a question about supporting their employees with those disabilities, or how to apply, or they feel like that maybe there's something was done incorrectly, they made the wrong decision, how can you help them as well?
Unfortunately, we only assist the injured employees because that's our main focus. But I do know that employers that's the reason why it's strongly encouraged for them to get workers' comp insurance. So that way, the workers' comp adjusters and their representatives are very trained in the workers' comp law, and they're able to provide the resources for the employees to prevent injuries, because no one wants to get injured at work. And so we assist the injured employees, but the employers themselves can also get covered by workers' comp insurance, and they have very trained professionals. I deal with them every day. The Texas Workers' Comp insurance companies here in Texas, and they're very, very knowledgeable. And that's a good resources for the employers for any workers' comp related inquiries or any prevention that they need.
I also, sorry, I want to jump in. I wanted to add that that would probably be something that you could contact the Division of Workers' Comp for. Since they're the regulatory agency, I think that they would provide information to any of the groups that I mentioned earlier, like employers, insurance carriers, healthcare providers, I think even attorneys. So if you're an employer and you want to know more about workers' comp or things of that sort, I would probably reach out to them.
Okay. All right. Awesome. I think we're out of time. So thank you so much for taking the time to share this important information with us. And we do know that, workers' comp, we don't think a lot about these things until the incident happens to us. So being well informed would help us to be more well informed. So for something that happens to them. So again, thank you for your time and have a great rest of the week.
Thank you so much. You too.
Thank you.